This case is the worst example of representing yourself in court. In this video, I'm going to compare the Wisconsin state case versus Darrell Brooks Jr., who insisted on representing himself in court. We will examine parts of the trial and compare it to UK law. To give you some background, Darrell Brooks Jr. was arrested, charged, and found guilty of the WAUKESHA Christmas Parade attack. We can see here on the left the suspect as he drove through the crowd, killing and injuring several people on November 2021 who were watching and participating in the Christmas parade. You can see Darrell Brooks Jr., the defendant, on the right. Many news outlets released videos on what happened that day. Before we get into it, if you are new to my channel, I am Karen Cole from Legal Minded Friends. I am a lawyer who assists people who want to represent themselves in court. My videos will hopefully provide you with information you may not know and give you resources to help you through a legal worry. I will play clips from the trial and compare it to UK law. Let me set up this clip that we're going to watch now. In America, you have a right to act as your own attorney, and the defendant had requested to release his solicitors.
Good afternoon, everyone.
Object to that.
I'm sorry?
I'm here representing myself pro per.
All right, thank you, sir. Then we are here so that I can once again address the motion to withdraw that was filed by the defense attorneys in this case late last week.
In the clip we just saw, Darrell Brooks makes his first mistake. You do not interrupt the judge when the judge is speaking, and we will see this throughout this trial. In the UK, if you want to change your solicitor, you would have to fill in a form, and your current solicitor would have to write to the court to say they would like to be taken off record. In this next clip, the defendant is arguing with the judge. He seems to think it is unfair that the judge allowed him to represent himself, and the judge is about to explain her prior ruling that he could represent himself.
Clearly read, write, and understand English. That's not an issue here, sir. Are you self-represented? Absolutely. Does that present difficulties and disadvantages? Absolutely. But that takes me back to when you waived your right to counsel, and you did so knowingly, freely, voluntarily, and with a full understanding of the disadvantages and advantages of doing so, meaning advantages of having an attorney, the disadvantages of doing it on your own, and you made a deliberate decision to represent yourself, and that comes at a risk to you of, yes, at times not fully understanding the law, the rules of evidence, the rules of procedure, but you do so at your peril.
That's not fair to state, Your Honor, because you want to refer to the waiver of counsel, which, again, for the record, you accepted it the way that I gave it to you, which clearly states on there, I do not waive my right to assistance of counsel, and you accepted that. But you still turn around and continue to violate my Sixth Amendment right.
In the UK, you have the right to speak for yourself in court without a solicitor or legal professional. You may choose to do this because, 1, you think it's better to talk directly to the judge, jury, or magistrates yourself, or 2, you cannot afford to pay legal fees. If you choose to represent yourself, you'll be known as a litigant in person. You'll also be known as the applicant, respondent, or defendant, depending on whether your case is heard in a family, civil, or criminal court. You may also be allowed to have someone to help you in court, taking notes and giving advice, but they cannot speak for you, as in our system, barristers are advocates who can speak for you. In special circumstances, the court may give permission for your legal assistant or Mackenzie friend to speak if the judge is confused as to what you are saying. Though it is important to note also that your legal assistant cannot take charge of your case or sign documents on your behalf. In this next clip, we're going to see the defendant is arguing with the judge that he was not offered an opportunity to change his plea, and the judge is trying to explain what he was offered.
That offer was conveyed to you.
It wasn't conveyed to me, Your Honor. This is the first time I'm hearing of it. So if it was conveyed to my former
It's
counsel,
not something I'm going to further address, sir, unless you indicate to me that you would like to take advantage of the pretrial offer by changing your pleas to either guilty or no contest to counts 1 through 67 and submit the appropriate paperwork. I'm guessing that's not what you want to do. So unless that paperwork were to be filed, then I'm going to continue with this trial as if you are exercising your right to a trial in this matter.
In the UK, you must plead guilty or not guilty. If you fail to make any plea, this will result in a not guilty plea being recorded, and the case will be set for trial. You can change your plea by completing a form prior to the court sentencing you. You would do this to remove aggravating factors that propel the charge into a higher sentence. If the prosecution does not accept your guilty plea on a proposed basis, the court will have a pre-trial to determine the facts being put forward by the Crown Prosecution Service and yourself, and the judge will then decide what facts are going to be part of the trial. You can pause this screen recording of what a court would consider aggravating factors. The judge will decide either to accept your reasons or not. A no contest plea that the judge talked about in this trial we are watching means that you accept the conviction, but you do not accept the factual admission of guilt. And in England and Wales, this plea is not permitted. Rather, our system is if you plead guilty, but you find out the facts put forward by the Crown Prosecution Service are not facts you can agree to, then your guilty plea is on a proposed basis. In this next clip, we're about to see the defendant questioning his ex-girlfriend on the night of the incident. As you will see, another argument ensues, and the judge intervenes.
Good morning, Miss Patterson.
Good morning.
So what do you do for a living?
I have my CNA certificate.
Do you recall what you were doing that evening?
I was hanging out with my friend Corey at Frame Park. I had spoken to you, Mr. Darrell Brooks. You came out there at Frame Park and met me after Miss Corey separated from me with her friend. Me and you got into an argument.
Whoa. Pursuant to the question?
I am answering your question.
I was referring to the judge.
It's inadmissible. She will not be questioned, and under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
Before I answer what would happen in the UK, in this trial, the ex-girlfriend had made a complaint of domestic violence on the night of the incident. So she alleged that he had punched her in the face. So he was also charged with this. In the UK, you are not permitted to cross-examine a victim of your domestic violence or abuse. And the court will appoint an advocate to question the witness. The other thing that the court may ask you to do is put your questions that you would like the witness to answer, and if the court thinks the questions are appropriate, then they will allow the advocate to question them. In this next clip, we're going to see that the district attorney is about to present something to the defendant. The defendant does not like the way she has spoken, and he starts to argue with the court.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had to be said. So it's the defendant.
That's not how it was said.
That was how I said. You want to run the record back?
Mr. Brooks.
So I'm the only.
Well, you decide, was the DA just a little bit harsh in the way she said defendant? In the UK, we are taught to keep an even tone. The court actually expects us not to show emotion or any form of bias. And it is no different for a litigant in person. You must not show emotion. Keeping emotions intact is one of the hardest things you'll ever have to do as a litigant in person because you are so invested. As we can see in this case, the defendant has been rude and should have been found in contempt of court many times. However, the judge does go on to say that she expects everyone to be respectful in her court. In this next clip, what we're going to see is that the judge is trying to organize the witnesses and when they are coming to give testimony. And the defendant has been very argumentative again, but when I answer the UK question, you'll find out why he's a bit confused.
Into court so that they can work with those witnesses
I'll probably
better.
say I'm not going to provide a specific order. I'm not going to do that.
Well, then you need to tell which day, like morning and afternoon, and how many witnesses per. I'm not going to just bring them in all at the same time and make them wait. That's not, that would be a discourtesy to those witnesses who you are calling. So I want to have some idea of what your game plan is for them.
That, but
All right.
I'll probably have an idea of who I think should come in, but I'm not going to provide an order.
Well, if he wants our assistance, Your Honor, we will do that. Otherwise, he can be responsible for getting these witnesses here himself.
You've got to cooperate with this process or they're assisting you. Otherwise, you're going to be responsible for telling these witnesses when to come in.
And so how am I supposed to do that?
This is no different to the UK. Each side must tell the judge what order they'd like their witnesses to be in, how much time they're going to need. The other side also gets an opportunity to say how much time they will need to cross-examine. The court then schedules the witnesses in accordance to how the hearing or trial is going. The problem we have with this case, and it would be a problem in the UK as well, if you're incarcerated, it's going to be very hard for you to use the telephone and computer while you're in prison. With this case, this is what he's trying to tell the judge, that he can't really organize people. In this clip, we're going to see that the judge is trying to ask the defendant to call a witness. He does not want to call a witness because he wants the court to deal with a prior question that he had. The judge is getting very annoyed with him, and watch and see what happens.
You that I had some legal issues that needed to be addressed before you just run right past that, Your Honor. You're a public
Mr.
servant.
Brooks,
Are you not a
it is
public servant?
9:37. Call
It is
your...
8:37.
Sorry, 8:37. You're right. Call your next witness.
Your Honor.
In the UK, you could be found in contempt of court if you're wasting the court's time or being argumentative. But technically, was he wasting the court's time by correcting the court when the judge said the wrong time? As the judge will decide your sentence, they will take your conduct in court into account. So you should be mindful of this. The other thing to keep in mind is if you plead not guilty and you are found guilty, the court will also take into account if you are sorry or remorseful. Darrell Brooks showed no remorse for plowing down people of all ages. Well, what do you think of Darrell Brooks's behavior in court? In my opinion, the evidence was so overwhelming against Darrell Brooks that he knew he would be found guilty. So his outbursts were, in my view, his lack of control. He was too invested. And he was found guilty on 77 charges and is scheduled for sentencing, facing 6 life sentences plus 859 years in prison. If you want to be a litigant in person in England and Wales, you have legal support. At Legal Minded Friends, we help you to understand the decisions made by the court so you can show respect for the court. We assist you with the legal process and help you to present your case to the court in a fair and balanced way. Please contact us if you need legal help. Please subscribe free, like and share as it helps our channel to grow. Remember, information is power, so why not watch some of our other videos?